Welcome to the Supreme Court of the United Kingdom. We are sitting remotely at present because of the coronavirus problem, and so the various justices forming the court and counsel who will be addressing us are all in different locations linked by video conferencing software. Today we are hearing an appeal in the case of Stoffel Co and Grondona. The case is concerned with the effect of unlawful behaviour on a claimant's ability to bring a claim. The facts are set out in more detail on our website, where you can find them by clicking on the link to current cases. Counsel in the case are Mr. Michael Pools, Queen's Counsel for the appellant, Stoffel Co, and Mr. Andrew Warnock, Queen's Counsel for the respondent, Ms. Grondona. I'm Lord Reed, the President of the Court. The other justices sitting with me in this appeal are first Lord Hodge.
Good morning.
Lady Black.
Good morning.
Lord Lloyd-Jones.
Morning.
And Lady Arden.
Good morning.
Without further ado, I'll ask Mr. Pools to begin his submissions on behalf of the appellant.
My learned friend, Mr. Stacey, my learned friend, Mr. Warnock, Queen's Counsel, leads Mr. Riffat and Ms. Giacciardi. This is, as you know, an appeal from the judgment of the Court of Appeal dated the 13th of September 2018, in which the court upheld the judgment of Her Honour Judge Walden Smith in the Central London County Court, which in granting judgment in the sum of £78,000 plus interest to Miss Grondona. The appeal concerns a relatively short but important point, namely the proper operation of the issues and the approach to issues of illegality or ex turpi causa set out by this court in the decision of Patel and Mirza. As you know from the agreed statement of facts and issues, my clients, the solicitors, were retained by Miss Grondona for the purposes of conveyancing of 73 Beulah Road, Thornton Heath, Surrey, which she was purporting to purchase from Mr. Cephas Mitchell. This arrangement was central to a mortgage fraud being operated by them upon the Birmingham Midshires Building Society, which eventually became the Bank of Scotland. What was in fact being effectively undertaken was the refinancing of Mr. Mitchell's financial affairs. The transaction involved a series of dishonest misrepresentations to the Birmingham Midshires, and in return for her agreement to be involved in this conspiracy, Mr. Mitchell agreed that he would discharge the repayments that would be due. He would keep all of the income from lettings of the property, and when he decided to sell, Ms. Grondona would share the profits. So far as they were concerned, it would appear that all went reasonably well for a number of years, until no doubt in the context of the 2008 downturn, Mr. Mitchell stopped paying and Ms. Grondona went into default. The solicitors had negligently failed to register the charge and lodged the discharge form DS1 of Mr. Mitchell's earlier charge upon the property, which was held by a lender called B.M. Samuels. Mr. Mitchell had clearly taken advantage of this over the years and had continued borrowing from the lender, effectively new borrowing, as a result of which, when the matter came to light, Birmingham Midshires couldn't exercise its charge on the property and obtained instead a money judgment against Ms. Grondona. By the time of the trial, negligence was admitted, but it was asserted that Ms. Grondona's claim was barred by reason of her own unlawful conduct. At the time of the original judgment in the County Court, Tinsley and Milligan was still the leading authority in this area, and the trial judge applied that decision in rejecting the defence. By the time the appeal was heard by the Court of Appeal, Patel and Mirza had been decided by this court. And so the Court of Appeal applied its approach to Patel and Mirza to the facts found by the trial judge and upheld the judgment, rejecting the appeal. We submit briefly that the Court of Appeal fell into error in its application of the Patel and Mirza principles to the facts of this case. I can, I hope, deal with the correct approach, which is common ground between the parties, very briefly. It's set out in the statements of case and the written case. The relevant passages of the judgment of Lord Toulson can be found in the index to the bundle of authorities at flag 3, page 364 of the bundle, at paragraph 120. In fact, I've started with a bad reference. I'll start, if I may, at page 359, at paragraph 101. Having set out the history of the approach of the court to the issues of extirpi or illegality, Lord Toulson, who delivered the effective majority judgment in the split court, sets out what is effectively a new approach at paragraph 101. I take it for these purposes that the court is sufficiently familiar with the facts of Patel for me not to need to go back there for the purposes of these submissions. He starts the paragraph by commenting upon an earlier article by Professor Burrows, and later on this morning we will return to one of Professor Burrows' more recent works, and goes on to ask the question, how is the court to determine the matter if not by some mechanistic process? In answer to that question, I would say that one cannot judge whether allowing a claim which is in some way tainted by illegality would be contrary to the public interest, because it would be harmful to the integrity of the legal system, without A, considering the underlying purpose of the prohibition which has been transgressed, B, considering conversely any other relevant public policies which may be rendered ineffective or less effective by denial of the claim, and C, keeping in mind the possibility of overkill unless the law is applied with the due sense of proportionality. We are, after all, in the area of public policy. That trio of necessary considerations can be found in the case law. I think it is common ground between the parties that although that trio of considerations could certainly be found in the prior case law, not, I think, in quite the way in which they were set out by this court in Patel. And Lord Toulson goes on after that new approach, as I think one rightly describes it, and looks back at how the court has come to that conclusion. I would draw your attention in passing to paragraph 105, going back as far as the decision of 1957 in St. John's Shipping Corporation, a decision of Mr. Justice Devlin, as he then was, where he questioned whether public policy is well served by driving from the seat of judgment anyone who has been guilty of a minor transgression. I point that out in passing because our submission is that what we are concerned with here is not what might be termed on any view a minor transgression. The next relevant passage of Lord Toulson's judgment we submit is found at paragraph 107, dealing with the question of disproportionality, as I'll call it. And he says, in considering whether it be disproportionate to refuse relief to which the claimant would otherwise be entitled as a matter of public policy, various factors may be relevant. Professor Burrows' list is helpful, but I would not attempt to lay down a prescriptive or definitive list because of the infinite possible varieties of cases. Potentially relevant factors include the seriousness of the conduct, its centrality to the contract, whether it was intentional, and whether there was a marked disparity in the parties' respective culpability. Now again, neither side before you today is submitting that this is, as it were, a statute, but they are clearly, I think, by common consent, important considerations, and we on our part will certainly be addressing you on the basis of those clearly, we would submit, obvious constituent considerations. And so in cases of proportionality, Lord Toulson goes on in the next paragraph, 108, which is on page 361 of the bundle, to discuss flexibility and cites the parking I case at F as a good example of a case where denial of the claim would have been disproportionate. And he continues, the claimant did not set out to break the law. If it had realized that the letters which it was proposing to send were legally objectionable, the text would have been changed. The illegality did not affect the main performance of the contract. Now, clearly, parking I is a case involving a contract between two parties, and the subsequent dispute was between those two parties. We entirely accept that in the present circumstances, the solicitors are independent of the unlawful conspiracy. But in our submission, there is a world of difference between the position of Ms. Grondona and the claimant in the parking I case, who did not set out to break the law. Ms. Grondona, as we will submit, patently did. The whole point of this transaction was founded in unlawful conduct. The final paragraph I would draw your attention to is the summary and disposal, which again pulls Lord Toulson's principles together at paragraph 120 on page 364. The essential rationale of the illegality doctrine is that it would be contrary to the public interest to enforce a claim if to do so would be harmful to the integrity of the legal system, or possibly certain aspects of public morality, the boundaries of which have never been made entirely clear, and which do not arise for consideration in this case. In assessing whether the public interest would be harmed in that way, it's necessary, A, to consider whether the underlying purpose of the prohibition has been transgressed, and whether that purpose would be enhanced by denial of the claim, B, to consider any other relevant public policy on which the denial of the claim may have an impact, and C, to consider whether denial of the claim would be a proportionate response to the illegality, bearing in mind that punishment is a matter for the criminal courts. Within that framework, various factors may be relevant, but it would be a mistake to suggest that the court is free to decide a case in an undisciplined way. The public interest is best served by a principled and transparent assessment of the considerations identified, rather than by the application of a formal approach capable of producing results which may appear arbitrary, unjust, or disproportionate. And that final phrase was clearly harking back to what by then I think in large part had become the discredited Tinsley and Milligan approach, where the answer to the question very much turned upon the precise way in which a particular dispute might or might not be pleaded as a matter of formality. So it's in that context we come to consider the particular facts of this case. But before I do that, perhaps I might also take you to what we would submit is a helpful approach to the analysis set out by Professor Burrows post the decision at flag 11 of the authorities bundle, which starts at page 655. But if I can take you to page 667, and in particular to the footnote, and it's footnote 35. And in the context of a debate as to whether or not Lord Toulson's approach demonstrates a structured approach, which Professor Burrows clearly favours. And he suggests that one way of applying structure to the approach set out by Lord Toulson is as follows. Under A, one is asking, are there policies of which the root policy is the purpose of the prohibition, which indicate that a claim should be denied, i.e. that the illegality defence should succeed? If there are no such policies, the claim succeeds. The illegality defence fails, and one need go no further. But if the answer is that there are such policies, one then goes to B. Under B, one is asking, are there policies going the other way, indicating that the claim should succeed, i.e. that the illegality defence should fail? If there are such policies, they have to be weighed up against the policies in A. Presumably, if the policies under B outweigh the policies under A, the claim should succeed, the defence of illegality fails, and one need go no further. But if the policies under A are stronger than the policies under B, or if the weighting is inconclusive, one must go on under C to consider whether denying the claim is a proportionate response, taking in all sorts of additional factors, e.g. The comparative blameworthiness of the parties, the seriousness of the illegality, the centrality of the illegality, etc. And he says, finally, so in one sense, the approach may be said to be structured, but as I understand it, the expectation is that in the vast majority of cases, one will get to stage C. In other words, I think the expectation is that it will be rare to stop at A or B. And he expresses his gratitude to Mr. McBride for that view. And you may feel that in addressing the considerations set out by Lord Toulson, that short footnoted debate is actually of particular assistance, because in our submission, that does demonstrate a staged consideration in a structured sense of the issues which arise as a result of the approach Lord Toulson sets out. So the first consideration, therefore, is the underlying purpose of the policy we submit is central to the illegality defence in this case. And that is that this was, at its root, a transaction in which the solicitors were peripherally concerned, but necessarily concerned, albeit innocently, whereby Ms. Grondona and Mr. Mitchell conspired together to defraud the Building Society. We set out in our written case at paragraph 10 the various criminal offences which exist. And at paragraph 9, we very briefly take an extract from the judgment of Lord Sumption in the Les Laboratoires Servier case, where he says something which we would submit is relatively, for these purposes, trite or obvious. The illegality principle is concerned with claims founded on acts which are contrary to the public law of the state and engage the public interest. The paradigm case is a criminal act. And clearly, we submit that the transaction giving rise to the instructions to the solicitors was, at its heart, a criminal act for the purposes of obtaining money which Mr. Mitchell and Ms. Grondona could not otherwise obtain. The dishonest misrepresentations were an essential step in obtaining that money. the instruction of the solicitors was an essential step in obtaining that money. There was, in fact, as between Ms. Grondona and Mr. Mitchell, no real intention to transfer the property. The Court of Appeal spent quite some time debating the question whether or not this was a sham transaction. In our submission, that debate does not take matters significantly further. As between Ms. Grondona and Birmingham Midshires, patently it was not. As between Ms. Grondona and Mr. Mitchell, as the trial judge found, patently it was. This was a transaction being undertaken with Ms. Grondona and Mr. Mitchell going through the motions of whatever they had to do for the purpose of extracting the money from the building society. So we submit that the mortgage fraud with which we are concerned at the heart of this plea of illegality was rightly described by the Court of Appeal as a canker on society. It has been prevalent and a very great problem. And for those of us practicing in the field, learned friend Mr. Warnock and I practice in, something which has kept us far, far too busy for far, far too many years. But nevertheless, it has proved recalcitrant, frankly, to control. And one wonders whether in the present economic circumstances, even as we speak, it may be a problem which in the months and weeks, years to come is going to re-emerge in all its cost for society as a whole. We submit that the underlying policy, therefore, is to discourage in all material respects involvement in criminal conduct of this kind. And we submit that in considering whether the denial of the claim would enhance the underlying purpose, that is to say deterrence, it would. It is not open, we submit, if this claim is denied, for people in Ms. Grondona's position to reach a view, this is a zero-cost risk so far as I am concerned. There is a remote possibility of being prosecuted. I am risking nothing. I am therefore impervious, realistically, to what happens by simply applying my name to this matter. Of course, that is superficial. Ms. Grondona could have been exposed to loss of money in any event by a downturn in the market. But realistically, when these transactions are undertaken, those undertaking them are focusing on the immediate reward, which was the mortgage advance rather than anything else. That was enhanced by in Ms. Grondona's case, because she also had the prospect of a very substantial share of the profit, if a profit did emerge once this property was sold some years later. So we submit for those reasons, and for the underlying reason that it's important that fraudsters understand that they will not obtain the protection of the courts in the great majority of cases, that the underlying policy favors the existence of the application of the illegality defense in a case such as this. The consideration of this issue at, as it were, the subparagraph A issue of Lord Toulson's judgment is addressed by Lady Justice Gloucester in the Court of Appeal at paragraph 37, which is, I think, page 117 your bundle. She has set out her history. She has, as you've seen, embarked upon the debate as to the relevance of whether or not the transaction was a sham. And she now turns to Lord Toulson's criteria that I have set out earlier. And she continues at paragraph 37. So far as the first consideration is concerned, the underlying purpose of the prohibition which has been transgressed, mortgage fraud is, of course, a canker on society, and it is extremely important that dishonest applicants for mortgages should not be empowered by the law to abuse the system. She then continues, however, I see no public interest in allowing negligent conveyancing solicitors, or in financial terms, their insurers, who are not a party to or know nothing about the illegality, to avoid their professional obligations simply because of the happenstance that two of the clients for whom they act are involved in making misrepresentations to the mortgagee financier. On the contrary, it seems to me that there is more likelihood that mortgage fraud would be avoided if solicitors appreciate that they should be alive to and question potential irregularities in any particular transaction. Moreover, the premise that it would assist the fight against mortgage fraud if mortgagors involved in making false representations to mortgagees were unable to recover if their solicitors were negligent in failing to register the mortgagee's security seems, to say the least, questionable. Further, this was a case where Birmingham Midshires, the mortgagee, made no complaint of fraud against the claimant, nor did it seek to reclaim its loan on the basis of fraud. Now, in our submission, what the Court of Appeal has done there is, although it says it's going to consideration B in paragraph 38, has actually loaded into its consideration of a number of completely extrinsic matters. In our submission, the answer to the consideration under subparagraph A is provided at the end of the second sentence. Mortgage fraud is a canker on society. It's extremely important that dishonest applicants for mortgages should not be empowered by the law to abuse the system. And what that means in our submission is it should not be able to obtain the assistance of the law. Lady Justice Gloucester then continues, however, I see no public interest in allowing negligent conveyancing solicitors to avoid their professional obligations simply because of the happenstance. That might be a consideration under B, but it's not a consideration under A, under any circumstance. But further to that, in our submission, to describe what is happening here as a happenstance to the retention and the error of solicitors is to understate the importance as a matter of policy, as well as a matter of fact in this case, of the mortgage fraud which occurred. The only reason these solicitors are being instructed is to allow the fraudsters to get to the stage where they obtain the money. It's an essential step in the conspiracy to defraud. And to describe that as a happenstance is firstly not a material consideration under subparagraph A at all. And even if it were a material consideration, substantially, catastrophically understates its importance. The Court of Appeal continues, on the contrary, it seems to me that there is more likelihood that mortgage fraud would be avoided if solicitors appreciate that they should be alive to and question potential irregularities in any particular transaction. Well, with respect, that juxtaposition is stating the obvious, but plays no part in the present case. It was never suggested that the solicitors failed to be alive to potential irregularities, up to and including the very end of her oral evidence to the trial judge. Ms. Grondona denied the fraud. Nobody ever suggested in this case that there was fault on the part of the solicitors, so far as Ms. Grondona's detection was concerned.
Isn't there another point in this sentence and the following sentence on which I would like your submissions, if I may? They both seem to be statements, to me, speaking as a law commissioner, which require evidential basis.
Certainly. If you are going to conclude that mortgage fraud would be avoided in the context of assessing illegality in a particular case, you have to undertake an analysis of what the solicitor has failed to do. It is the sort of analysis which is undertaken by this court in the Singularis Holdings case, where the allegation against the bank was that the bank had failed to detect the irregularity which was going on, which was the whole point of the illegality plea. And there was an intimate connection between the bank's fault and the very illegality which it relied upon.
It's a little difficult to follow the train of thought even earlier in the paragraph. At least I'm having a little difficulty. In the second sentence, she says that she sees no public interest, read short, in the failure of the claim. Well, of course, the public interest is a public interest in effectively criminals not benefiting from their crimes. In the first sentence, the way she puts it is that the public interest is the importance that dishonest applicants for mortgages shouldn't be empowered by the law to abuse the system. I'm not sure what she means by that, but she doesn't seem to, when she talks about not being empowered by the law to abuse the system, she obviously doesn't have in mind recovering damages from the solicitors because they carried out their part in the furtherance of the scheme negligently, because she sees no public interest in preventing that.
I'm not sure that I can shed a great deal of further light on that, my lord, I'm afraid. The key question is whether the nature of the illegality and the underlying policy is such that the person who has been involved in it cannot seek the assistance of the law in these circumstances. Yeah. And it is clear from Lady Justice Gloucester's approach that she considers that that is outweighed by the need to hold the professional man to a non-negligent standard of conduct. But A, that is not part of the consideration under A, and the consideration of the underlying policy under A is fundamental, because until you've assessed what the underlying policy under A is, you can't balance it with the value of a negligence claim, which is a public policy under B in our submission. But in order to undertake the balancing exercise, you have to assess the two respective issues and the value, the import, the effect, the importance of the underlying policies. Lady.
Lord Jones was probably before me, actually, in the queue.
Sorry. Lloyd Jones, you've got a very bright light to your right, which makes it very difficult to see your hand.
Well, I can remove the light, but you may not see me in those circumstances.
I'm sorry, yes. If you could move it slightly to your right, if it's possible. It's just right on the edge and dazzles.
Mr. Pools, we've been round this one, I'm afraid,
Ah,
on previous occasions. Lady Black, going first, or am I? Right.
I think you've been deferred to.
Pools, you said a moment ago that there was no criticism in the proceedings of the solicitors having failed to be alive to irregularities. And indeed, in your written case, you say there was nothing to put them on notice. But this was a situation in which the second purported sale was within 6 months of the first, and the consideration was 3 times the amount, if I'm not mistaken.
That's true. But there was no investigation into, for example, whether or not the lender knew that.
Right. Thank you.
I mean, your lordship is, of course, correct. That is true. And similarly, it is also the case, as my learned friend points out in his written case, that the solicitors were acting both for the vendor and for the purchaser.
And indeed for the building society.
And for the building society.
Yes.
And again,
my concern is with your statement. There was nothing to put the solicitors on notice that there was any irregularity here.
Well,
surely those are matters which should have sounded alarm bells ringing.
my lord, I accept that in the abstract, those are matters which can sound alarm bells. What was never investigated in this case was whether they did, and if so, what steps were taken. So, my lord, in those circumstances, it cannot be said in our submission that the solicitors should have acted upon alarm bells, because although there are issues there which may have been flags, without an investigation by way of allegation and response as to what those flags led to, it's not a matter which the court can take properly into consideration. The case against Stoffel, brought by Ms. Grondona, did not seek to pray in aid any such matters.
Thank you.
Milady.
My contribution to this debate is a lot more pedestrian than that. If you moved, going back to paragraph 37, if you moved up the shift to consideration B and put it in just before however in paragraph 37, then the structure would be a lot clearer, wouldn't it?
I was trying, not very clearly, to make that point.
I think you're using it as a forensic point to criticise the Court of Appeal's reasoning, but actually the considerations that they take into account, you might criticise those considerations, but they are properly doing so under the structure of Mirza.
I think my criticism, milady, is not so much as to the structure, but the Court of Appeal is very light on its consideration of consideration A.
Yeah, I see that.
And until you identify what consideration A is, that is to say, the import of the canker, it's difficult to see how you go about the process of balancing the two. And it appears, as it is set out, that what the Court of Appeal has done is to, as it were, import a chunk of potential B considerations into A, which obviously has the potential, we submit, had the potential and did distort the exercise.
They may have thought that it spoke for itself, consideration A,
well,
without being elaborated.
My lady, that would be possible, except for the fact that paragraph 38 starts with the words "on the other side of the coin."
Yes, but what we're doing is identifying the things which go into each side of the balance. They've identified it. It's a canker. They move to B.
Well, my lady, I understand what you're saying, but as it reads, it looks as though the rest of paragraph 37 is being set out as under considering issue A, because otherwise paragraph 38 would not start with the words "on the other side of the coin," which is B.
I understand that editorial point.
Can I just ask you, Mr. Pools, as you'll know, there's something of a debate as to what is the appropriate approach for an appellate court to follow in cases of this kind. And we may or we may not need to get into that issue. But just to understand what you're doing at the moment, are you seeking to persuade us that the Court of Appeal has erred in law in failing to apply on a correct understanding of them the guidelines, the approach which Lord Toulson laid down in Patel and Mirza?
Lord, I am. I mean, when we get towards the end, hopefully, to a few words about the whole question of discretion and exercise, it will be important to bear in mind here that firstly, there is an important debate as to whether or not the employment of these public policy considerations is actually properly viewed as an exercise of discretion at all. Clearly, we would submit it isn't. And secondly, the Court of Appeal was here in a rather unusual position insofar as, by common consent, the law had moved on since the trial judge had made her conclusion upon her findings of fact. And what the Court of Appeal was doing was something much closer to a trial at first instance, insofar it was taking the findings of fact which had been made below and applying the new and correct approach to them. So in many ways, you are very much similar to a court of first remove rather than a court of second remove in appellate terms in addressing this. But in our submission, whilst there are issues of fact to which we draw your attention, at the heart of our appeal is that the Court of Appeal went about it in the wrong way, as we have illustrated. What is lacking here is the identification of the material to undertake the correct balancing exercise. So what my learned friend on behalf of the defendant says in his skeleton is found in his written case. It starts effectively on page 84 of the bundle at paragraph 31. For the reasons the court gave discussed further below, it's submitted that the Court of Appeal was right indeed to bar the claim on the grounds of illegality, would undermine and impugn the interest in the property which the law recognizes transferred to Ms. Grondona. And in our submission, that submission very much bears out our primary point under consideration A, which is that the reason why this was a proper case for the defense of illegality to apply is that the court has no business in upholding the interest in the property asserted by Ms. Grondona, because it is a false assertion, as she readily accepts, or must accept in the light of the judicial findings as to the sham nature of the transaction between herself and Mr. Mitchell. My learned friend goes on, and rightly goes on, at paragraph 32, to accept that the Court of Appeal rightly started with the proposition that mortgage fraud is a canker on society, and that it is extremely important that dishonest mortgage applicants are not empowered to abuse the system. He then goes on to say the civil courts shouldn't undermine the effectiveness of the criminal law, but they should not impose in substance an additional penalty. In our submission, this isn't an additional penalty. This is a party coming and seeking the assistance of the court in circumstances where, in order to demonstrate what in fact was going on, it is necessary to investigate the underlying claim, and one finds that what is being sought is assistance in buttressing this lady from an adverse consequence of a fundamentally dishonest transaction. In paragraph 34, the learned friend denies that there is any deterrence effect in upholding this policy. The claim arises because solicitors were negligent in undertaking the most basic of conveyancing formalities, registration of title documents. Few fraudsters are likely to have an expectation or fear that their solicitors might turn out to be so incompetent, or to be put off by the possibility of not being able to sue their solicitors by the unlikely prospect that they transpire might be able to do so. What we submit is this. It's impossible to look into the minds of potential fraudsters, but the message sent by the courts that if you are a party to a fraud of this type, you cannot expect the assistance of the court in to extract secondary remedies against third parties, be they surveyors, solicitors, or whoever, will eventually, we would submit, come home. The learned friend goes on from that to say at paragraph 35, the underlying prohibition, the underlying purpose of a prohibition against mortgage fraud is to protect the mortgagee and the public. Absolutely, and that's why it is so important to reinforce, underline, and uphold that policy. Denying the claim would not enhance that protection. Well, with respect, insofar as it adds any part to discouraging mortgage fraud, it does. Denying the claim, the negligence occurred after the loan had been advanced. That is true, but that's neither here nor there. By the time of the alleged negligence, the fraud itself was complete. Well, insofar as the money had been obtained, I accept that that's the case, but the fraudsters had a continuing interest in concealing their fraud. Indeed, by the time of the negligence, it was not only in the interests of the borrower, but also the mortgagee that the various titles should be registered. I entirely accept that, and the solicitors were exposed to a claim by the mortgagees, and the claimant who has acted dishonestly cannot pray in aid the interests of the mortgagee who is able to look after his or her or their own interests and to pursue the solicitors insofar as they need to do so.
I wonder if Mr. Warnock in the case may not, in fact, have correctly identified or followed the reasoning in paragraph 37 of the Court of Appeal judgment. Looking at it again, I'm not sure it's right to say that this is really mostly concerned with point B in Lord Toulson's analysis. First sentence about the importance that dishonest applicants for mortgages should not be empowered to abuse the system. I think what it may be saying, put shortly, is that the relevant public policy is the prevention of mortgage fraud. And if that's so, then what follows makes sense, because she goes on to say, Lady Justice Gloucester, that there's more likelihood that mortgage fraud would be avoided if solicitors effectively took more care. So that's to do with the prevention of mortgage fraud. And then in the next sentence, the premise that it would assist the fight against mortgage fraud if mortgagors were unable to recover, she thinks is questionable. So she doesn't accept, this is a deterrence point. So she's saying that, I think she's saying, relevant policy is the prevention of mortgage fraud. Refusing claims against negligent solicitors is going to have no deterrent effect, and therefore does nothing to further that public policy. And on the contrary, holding solicitors liable would be more likely to encourage them to take care, which might further the policy of preventing mortgage fraud.
But the curiosity of that, if your lordship is right as to that construction, is that the fraudster is saying, the policy of discouraging mortgage fraud should not be applied against my claim because I can pray in aid that you ought to have been protecting my victim better, which in our submission demonstrates that it is a misapplication of the consideration. What we are addressing under A is the public policy of preventing the very conduct which the claimant is undertaking. The victims have a different interest, and there is a public policy of protecting victims and causing professional men to act competently in order to protect those victims. But the fraudster is not the person who can say, you ought to have done a better job in protecting the building society. That is in our submission, taking one public policy, that is to say, affording the best protection to the victims, and reading it across to the consideration of whether or not there is a public policy in discouraging the culpable party by depriving them of the benefit of access to incidental claims.
I'm wondering, like I think Lady Arden, I'm wondering about the entire premise here. I mean, the proposition that that various steps will contribute to the prevention of the commission of a particular type of criminal offence, that's a proposition of fact. And is that really, is what Lord Toulson is talking about in terms of public policy under A really meant to be as narrow as that? And if it is, what do courts require then to have evidence about what contributes to the prevention of criminal offences?
Well, my lord, it is, I fear, part of the difficulty one has to face judicially when one is involved in considering matters of public policy, because so often matters of public policy require an overall assessment which sometimes simply do not admit of evidence. How could one prove what is likely to impact upon the fraudster on the Clapham omnibus? Trying to think through what sort of evidence could address what must be accepted is a very real issue, apart from a policy judgment of the possibility or probability of an impact being directed. Perhaps the simple question the court has to address in its own mind is this: does the court accept that a consideration of this type could have an impact? And in our submission, that is a consideration which is a judgment, but isn't a judgment to which there can be factual evidence admitted, because it isn't accessible to evidence from the expert fraudster. There isn't a class of expert witness that could be called to speak to this.
You cannot have evidence in a court of law, but you could have evidence in the Law Commission process, because you would be consulting with more.
Mary, you were muted. I'm sorry, Lady Arden, you were muted there. We missed you.
Is that better? Thank you so much.
We can hear you now. We can hear you now.
My fault. My fault. I just wanted to say that in the Law Commission process, you would certainly have evidence through consultation, and you would be speaking to mortgagees and solicitors and people on the ground who do these transactions to know what shape the law should take in order to deal with a particular social evil. But that sort of question that sort of evidence is not available in a court of law. And especially in litigation which is purely adversarial. If you've got litigation which involves a whole sequence of actions and Brandeis briefs being put in and so on, then you might be able to answer some of these questions, but not in the normal process of the law. Thank you.
Melanie, I entirely accept that, and part of the problem which Lord Toulson and your court had to address in Patel was addressing an area of law which had given rise to very considerable difficulty, had given rise to a Law Commission report, and unfortunately had received no support that led the court to any hope that a legislative conclusion would be accessible.
A different approach would be to say that the relevant policy under A in cases of this kind is not an instrumental policy, which requires a certain response in order to bring about a certain effect. Rather, one possible approach might be to say that the policy of the law treats fraudulent conspiracies, for example, as very seriously reprehensible conduct. So serious that the law will be very slow to lend its assistance to a participant in such a conspiracy who is seeking, through the law, to either benefit or minimize a loss which would otherwise fall upon him or her. In other words, the law is adopting, the idea that the unavailability of civil remedies is going to have a deterrent effect on the commission of crime is almost absurd, it seems to me. It seems to me to be much more likely that what one is talking about, and one can relate to the earlier ideas about the coherence of the law, is that the law carries through the disapproval of this conduct, which one sees in the criminal law, into a reluctance to aid participants in such conduct in the civil sphere. That might be a policy.
Well, indeed, and realistically, when one stands back and considers whether there is an alternative, as it were, factual approach, there would be a very considerable risk that going down that factual analysis would expose the courts to very considerable difficulty in obtaining anything that could be recognized in a conventional sense as evidence. And in weighing that in any meaningful sense in a public policy realm. This is a public policy issue, and therefore it is likely in our submission that it is going to involve the larger picture.
Can I ask how Lord Toulson identified the relevant policy in Patel and Mirza itself?
If we go back, I think the important consideration in Patel and Mirza, before I try and track down the particular reference, was that it was an unjust enrichment claim. The underlying dishonest conspiracy had not been put into effect.
Yes.
So he wasn't confronted with somebody who was seeking to seek a remedy after the crime had been performed. So the conspiracy had been achieved, money had been paid over pursuant to the conspiracy, but the insider trading had never happened.
Well, I dare say we can come back to this.
My lord, it may be that it's a convenient moment to take the 5-minute break, and I can perhaps come back to it immediately afterwards.
Yes, by all means. Well, we won't leave the video meeting that we're in, but I think we'll switch off our video and audio feeds in the meantime, and we'll resume in 5 minutes.
Thank you. Thank you. I think the answer to your question can be found firstly at the foot of paragraph 100 on page 359. He was dealing there with the question of whether or not the application of the principle was limited to, as it were, claims for profit. And he cites with approval the decision in Hall and Hebert. And he cites the decision, and fundamentally, Mrs. Justice McLachlan expressed the view at pages 175 to 176 that as a rationale, the statement that a plaintiff will not be allowed to profit from his or her own wrongdoing doesn't fully explain why particular claims have been rejected, and that it may have the undesirable effect of tempting judges to focus on whether the plaintiff is getting something out of the wrongdoing, rather than on the question whether allowing recovery for something which was illegal would produce inconsistency and disharmony in the law and so cause damage to the integrity of the legal system. I think that's an important consideration so far as he is concerned. And then going on from there to paragraph 102.
In 101, I see opposite H, he talks about judging whether allowing a claim which is in some way tainted by illegality would be contrary to public interest because it would be harmful to the integrity of the legal system.
Right. And then he gives an example at paragraph 102 of where the policy doesn't apply because it's a driving while uninsured case.
Oh, no, sorry, it's still at 102. Sorry, 101. Below H, well, you have the trio of considerations. So
Yes.
it would be harmful to the integrity of the legal system without A, considering the underlying purpose of a prohibition which has been transgressed. So the prohibition in this case is the prohibition, in our case, the prohibition on mortgage fraud.
Exactly so. So it is looking at it. It is looking at the big picture. Yeah. What is the policy here? We are doing nothing which is inconsistent with the prohibition upon mortgage fraud.
Yeah. And the underlying purpose of that prohibition, I suppose, is to protect lending institutions from dishonest borrowers.
Yes.
Well, you could put it in a variety of ways, but that's one way of putting it.
Or alternatively, to maintain society's requirement of honest conduct.
Yeah. Yes. So he's not talking about some sort of cause and effect relationship between the denial of a remedy and the incidence of the particular offence.
No, not at all. It is a bigger picture consideration. I'm sorry, I think Lady Arden wished to say something.
I was going to say, this is a very big question. If you were writing a Law Commission report, you'd have several pages. But another example of the purpose served by mortgage fraud is this. Mortgages are important in economic terms as enabling owners of land to realise the value of the land for the purpose of investing in business and thereby increasing the economy. And so you've got to persuade people to lend money on the security of land. And so in protecting the integrity of the process is very important for economic reasons.
Yes, perhaps when one looks at the overarching public policy, there are a number of tiers to it. There is we require honesty in society. That's Section 1 of the Theft Act, as it were. Within the mortgage area, there is a particular vulnerability. And as the Court of Appeal rightly says, mortgage fraud is a canker on society, the reasons inter alia set out by my Lady Arden. So in our submission, this is a significant and important public policy issue, which we submit was not addressed with sufficient weight was not identified sufficiently clearly, and then not addressed with sufficient weight by the Court of Appeal. Perhaps I might then move on to, as it were, the countervailing, or the other side of the coin, consideration B. We deal with that at paragraph 15 of our written case.
Before you do so, please, Mr. Pools, can I just deal with one matter? Looking at the law of property, notwithstanding the illegality of the transaction, I think Ms. Grondona got an equitable property interest by virtue of the signing of the TR1 and the vendor having done everything in his power to transfer the property. Is that right?
Yes, she got an equitable interest in the transfer of the legal title.
Yes, yes. And in this particular case, the building society gave money on the conveyance without the title being in place, as will be no doubt a common thing to do. But if the building society had not advanced the money on the conveyance, let us say that she'd had the money, but was wanting to get a security in place that thereafter, could she have sued the solicitors to get them to record her title and the security in order to obtain the release of funds? Your answer presumably would be no, because that would be positively furthering the fraudulent transaction.
Quite.
Yes. And the difference in this case, if it is a difference, was the money had already been advanced, but the solicitors are being sued for failing to do what she could not have forced them to do in the other circumstance.
That's right. Their failure was the administrative failure to register, and I accept and must accept that that is after the funds have been received. But the registration is an integral part of the whole process.
Yes, but it's just I was trying to deal with the idea that the fraud was happenstance and was irrelevant really to the exercise.
The fraud is absolutely central to the whole transaction.
Yes, so you're facing a case where you're being sued for not having done something which certainly in other circumstances she could not have sued you to do.
Quite. And realistically, actually, if one steps even further back, she is suing because of the further dishonesty on the part of Mr. Mitchell, who must have known that he was taking money from B.M. Samuels, that the charge was still in place and he was defrauding his co-fraudster.
Thank you.
Well, Lords and Ladies, turning on then to consideration B, the Court of Appeal deal with this in paragraph 38 at page 117, and looks at Lord Toulson's second relevant criterion, any other relevant public policies which may be rendered ineffective. There is a genuine public interest in ensuring that clients who use the service of solicitors are entitled to seek civil remedies for negligence and breach of contract arising from a legitimate and lawful retainer. That is self-evident. However, although so far as the solicitors were concerned, they had no reason to doubt the lawfulness of their retainer, that is to disregard wholly the circumstances in which the retainer comes about. The Court of Appeal, Lady Justice Gloucester, described the retainer in the following words: in circumstances where the client was not seeking to profit or gain from her mortgage fraud, but merely to ensure that the chargee's security was adequately protected by registration. Well, with respect, the Court of Appeal is, as it were, driving or building a wall between the moment at which the money is received and saying, well, the fraud's over then, and thus categorizing the charging process as a mere protection. What we submit is that that is A, falsely separating out the process which is going on here, and B, is overweighing, overstating the underlying policy. Of course, there is a policy that those who are damaged by the negligence of professional men should, brackets, if they are entitled to it, close brackets, have a claim available to them. The question is whether that policy outweighs the public policy in respect of the consequences of dishonest conduct. And that then takes us back, as Lady Black, I think rightly identified, and I would have said, to the considerations set out in 37, which I accept would be material to the balancing process in 38. And we then get back to happenstance, the assertion that mortgage fraud would be avoided if solicitors were alive to and questioned potential irregularities. All of those are considerations applicable to the entitlement to bring an action on behalf of the victim. They're nothing to do with balancing the entitlement to bring a claim against solicitors with the dishonest conduct of the claimant. And finally, Lady Justice Gloucester says at the final sentence in paragraph 37, further, this was a case where Birmingham Midshires, the mortgagee, made no complaint of fraud against the claimant, nor did it seek to reclaim its loan on the basis of fraud, to which our answers are very short. They never had to. Why would you take upon yourself the obligation to prove a fraud when you have a perfectly good and unanswerable claim in debt? That can't have been a significant consideration of any sort whatsoever. Which brings us on to the issue of proportionality, which perhaps understandably Professor Burrows identifies as being the most likely.
Before you move on to proportionality, one of the reasons of policy, which was identified in Patel and Mirza, was to ensure that there was integrity in the legal system and that it didn't take away with one hand what it was giving with the other. And one of the elements in the legal system is the principle, which as I understand it is operated at least hitherto, that you can get good title under an illegal contract. And the remedies that you get for that good title seem to me to depend upon who it is you're seeking to enforce against. Now I'm wondering how the present circumstances fit into that set of principles. The Court of Appeal deal with it, I think, at paragraph 31, and from then, if the claimant here has got an equitable right, and I don't think we've seen any argument about that. It's asserted by the Court of Appeal she's got an equitable right and she's entitled therefore to be registered as the proprietor of the estate. How does it all fit with, who is she seeking to assert against here? Is it against Mitchell? Is it, I'm not quite sure how the law would treat this in that line of getting a good title authorities.
Well, it's a big question, and it's not addressed because our permission is only under the application of the Patel and Mirza approach to the case.
It comes into that, surely, doesn't it? Because it's a policy to have integrity in the legal system.
Of course, and I don't detract from that in any way. And I suppose the answer would be it rather depends upon who the dispute is between. In the present case, Miss Grondona did not sue the solicitors for her loss of the title as such. She sued them for the fact that she was unable to, she sued them for the loss that was caused by the fact that the charge did not mean that the building society enforced against the property. So far as a dispute between herself and Mr. Mitchell was concerned, the underlying agreement between them arguably vested legal title in her to hold it effectively on trust for him under the agreement, because he was going to receive the income, he was going to pay the outgoings, he was going to decide if and when it was sold. So as between the two of them, seemingly, she would have had a bare legal title. I apologize. As between herself and a third party, the third party wouldn't have gone behind the legal title. The equitable title would have been of no interest to them. And as between herself and the solicitors, her only complaint was, the building society wasn't able to enforce against the charge and take the house.
Yes.
So I'm not sure whether that answers your ladyship's questions, but it does illustrate how that question is an interesting question, but it isn't a question to which there is one absolute answer that I think points to any particular solution to integrity of the legal system. The integrity of the legal system, we would submit, addresses the remedies to be made available to the participants in a fundamentally dishonest transaction.
Thank you very much indeed, because as you saw from my question, I'm struggling even to articulate the question, let alone yet to see how it fits into this. Thank you.
Thank you. Which brings me to proportionality, which, as I was about to say, suggested by Professor Burrows as being the most likely question to give rise to issues possibly in the application of the tests to the future. And perhaps I can first look at how the Court of Appeal went about this and then make our submissions. It's dealt with in paragraph 39 on page 117. And Lady Justice Gloucester starts by saying, so far as proportionality is concerned, similar considerations apply. From which I infer that the court appears to be concluding that the genuine public interest in ensuring clients of solicitors are entitled to seek a civil remedy for negligence is the predominant consideration. I think that's the effect of what she has said so far. I accept the claimant's submissions that it would be entirely disproportionate to deny her claim if one takes into account the non-exhausted list of potentially relevant factors set out by Lord Toulson at paragraph 107. These include the fact that, although the misrepresentations to Birmingham Midshires were reprehensible, the reality was, and then we'll come on to the four considerations. But in our submission, where the Court of Appeal describes the misrepresentations as reprehensible. Reprehensible is no doubt what they were, but more importantly than that, they were out and out dishonest. They were criminal. And I think that it must be submitted that the terminology, and I don't want to put too much weight upon a single word, but it does suggest that the respective weight of the issues being applied by the Court of Appeal is wrong, because this was fundamentally dishonest behavior. Going on to the proportionality considerations, they are as follows. The victim chargee raised no complaint against her on the grounds of fraud, but adopted the transaction. Well, there are two considerations there. Firstly, the victim chargee may or may not have known of the fraud, but had no interest in whether or not it pursued a cause of action in fraud because it had a clear cause of action in debt. To say it adopted the transaction is curious in those circumstances. It's simply called in its debt. There could have been no consideration to the contrary. I think we may have lost Lady Arden.
Yes, we had better wait until we hopefully she returns. I think we're ready.
We were dealing with the question of proportionality. I had dealt with subparagraph 1 of paragraph 39. Subparagraph 2, the solicitor at the defendant firm did not allege fraud in his witness statement. That can't have been a material issue on proportionality. Firstly, he is unaware of it at the time. Secondly, what conceivable evidence could the solicitor adduce as to the fraud? Thirdly, how can that sound as a matter of proportionality? Subparagraph 3, the claimant did not seek to evade her obligations under the Birmingham Midshire's charge. Indeed, as the judge said at 49, she was legally responsible under the terms of her personal covenant. Again, with respect, she didn't seek to evade her obligations. There was no way she could. She had entered a contract with the Birmingham Midshires. The money had been received and she was due to repay it. Item 4, her illegal conduct was not central or indeed relevant to the otherwise proper and legitimate contract of retainer between the claimant and the defendant, or indeed to the claimant's claim in the present action. It was simply part of the background story. That's the fundamental point on proportionality in our submission. And it miscategorizes what was a fundamentally dishonest transaction from first to last. The only reason for retaining the solicitors, the quotes, otherwise proper and legitimate contract of retainer, was in order to take the necessary administrative steps for the mortgage fraud to provide the funds which were being sought. This transaction was only happening for the purposes of advancing the mortgage fraud. It was not happening for the underlying purpose of vesting legal title in Miss Grondona. That was no more than an incident which was necessary in order for the mortgage fraud to happen. So in our submission, the illegal contract was not only relevant, it was central. Item 5, the claimant's intention in pursuing the claim in negligence was not to profit from the fraud or indirectly to enforce her entitlement under her agreement with Mitchell to 50% of the profits on a sale, but rather to obtain funds to reduce or to discharge her liability in part or in whole under the Birmingham Midshires charge. That is true, but it is not, as in our submission, material to proportionality. The only reason why she is liable for that money is because she has entered into the fundamentally dishonest transaction. She is not profiting from the fraud, but she is seeking to be held harmless. In the circumstances, there was no risk that the enforcement of her claim would undermine the integrity of the justice system. In our submission, the proper approach to proportionality, balancing the claim by the fraudster against the negligent solicitor, does do precisely that, because it is permitting the fraudster to be held harmless for the consequences of entering into a transaction because of the fault of the solicitor and her ongoing relationship with the fraudster. The learned friend's response is seen in his written case at paragraph 87. And he seeks to uphold the conclusion of the Court of Appeal. In paragraph 40, the mortgagee, not the solicitors, was the victim of the fraudulent representations. It was it which advanced the money. It made no complaint against Ms. Grondona in its recovery proceedings or otherwise. That is entirely true, but it is, in our submission, nothing imports, because it is the fraudulent conduct which is fundamental to this, not that the mortgagee is the victim. Mention is made of the fact that compliance by the solicitors with their obligations to register title was in the mortgagee's interests. So it was, and the solicitors would have had no answer to a claim by them had they suffered loss. In addition, insofar as it was required to sue on her personal covenant, it was in their interest she should have assets. That is true, but again is nothing in point. Compensation from the solicitors for their negligence provides such assets. With respect, if they seek a remedy against the solicitors, it is for them to seek it. What the asset position of Ms. Grondona is, whether she is a woman of wealth or otherwise, is neither here nor there. Item 2, the fact the solicitor did not allege fraud in his statement. Although perhaps a lesser consideration, the fact that the conveyancing solicitor did not address the issue of fraud at all is surprising. Well, with respect, it's not surprising. What could he say? He could express opinion, which would be wholly inadmissible. He couldn't otherwise adduce any particular factual evidence. The fact that his role was essential to the fraud is self-evident. He had no reason to know that he was being used as the cat's paw. 3, the claimant did not seek to evade her responsibilities. I've made my submissions on that point. She had no choice. And then centrality, I've made my submissions. My learned friend says the history of how Ms. Grondona had procured the finance to obtain the title was irrelevant. And that is where we part company, and I've made my submissions on that. The learned friend then prays in aid the authority of the Court of Appeal in Sweetman and Nathan. That is a matter which was heard by the Court of Appeal in 2003. It's at flag 7 A matter in which I was unsuccessful in the Court of Appeal on that occasion. That was a remarkable case in many ways, but in our submission, it is by no means self-evident that the effort to strike out the claim, which was made and successful in front of Mr. Justice Stanley Burnton, but reversed in the Court of Appeal, would be decided in the same way today. It was a case that was obviously before Patel and Mercer. It was, in fact, before Tinsley and Milligan. So it was very much going back into the distant mists of the law, developing law in this area. But in our submission, it by no means follows that the outcome in that case, had a balancing exercise being undertaken in the way that it was and should be in the light of Patel, would have led to the same outcome. The two policy considerations, A and B, would have been very much the same. The additional complication in Sweetman is that Mr. Sweetman and Mr. Nathan were co-conspirators. Mr. Nathan was the solicitor. This claim, although nominally against Mr. Nathan as well, was principally against his innocent partners. Mr. Nathan having, I think by the time of this claim, if he was not already in prison, he was certainly on his way there. So the policy considerations A and B would have been, in our submission, very much as in the present case. This was a £1.5 million fraud on the bank, and clearly highly serious. It was central. The failed sale by the misidentification of the purchaser was central to the whole process of obtaining money. The conduct of Mr. Sweetman was intentional, and there was a patent disparity of culpability. Mr. Sweetman was at the middle of the fraud. The innocent partners were responsible for Mr. Nathan's negligence. In addition, of course, Mr. Sweetman knew that Mr. Nathan was a crook, which his innocent partners didn't. In our submission, were that case to come before the court today, the proper application of Patel and Mercer would lead to the opposite outcome. The learned friend then, at paragraph 49 of his written case, prays in aid the question of profit, and relies upon the fact that Miss Grondona's claim is for losses rather than to enforce an illegitimate gain. It's common ground, and it has to be on the terms of the agreement Miss Grondona entered, that her real benefit in entering this transaction in the first place was the prospect of a 50% share in any profit which accrued. This was not a case like Patel, where the fraud had not happened. The claim in Patel was a claim in unjust enrichment. This is a claim made after the fraud has been, as accepted by my learned friend, completed so far as the receipt of funds is concerned. My learned friend relies upon the passage in the Italian Supreme Court in Hall and Herbert. And we submit that, albeit that one word would require changing in the particular circumstances of the present case, the same approach is appropriate and to be applied in this case. The relevant passage is set out in my learned friend's skeleton at page 82. That may be the quickest way to it. Paragraph 22. all of the judgments in Patel prayed in aid and endorsed the judgment of Mrs. Justice McLachlan. The passage was quoted by Lord Mance, and I quote, "The narrow principle illustrated by the foregoing examples of accepted application of the maxim ex turpi causa is that a plaintiff will not be allowed to profit from his or her wrongdoing. This explanation, while accurate as far as it goes, may not, however, explain fully why courts have rejected claims in these cases. Indeed, it may have the undesirable effect of tempting judges to focus on the issue of whether the plaintiff is getting something out of the tort, thus carrying the maxim into the area of compensatory damages, where its use has proved so controversial and has defeated just claims for compensation. A more satisfactory explanation for these cases, I would venture, is that to allow recovery in these cases would be allow recovery for what is illegal. It would put the courts in the position of saying that the same conduct is both legal in the sense of being capable of rectification by the court and illegal. It would, in short, introduce an inconsistency in the law. It is particularly important in this context that we bear in mind that the law must aspire to be a unified institution, the parts of which, contract, tort, the criminal law, must be in essential harmony. For the courts to punish conduct with one hand while rewarding it with the other would be to create an intolerable fissure in the law's conceptually seamless web. We pray and aid that passage because we say, in the present circumstances, as against a particular case the Canadian Supreme Court was addressing, the appropriate approach is defined by taking the final sentence that I've just read you and just read it: for the courts to punish conduct with one hand while protecting it with the other would be to create an intolerable fissure in the law's conceptually seamless web. And that is what we say is being sought here. And that is consistent with Mrs. Justice McLachlan's deprecation of the focus upon profit. Profit isn't needed. What is being sought is the protection of the court, which is inconsistent, we submit, with the dishonesty undertaken by Mrs. Grondona.
Can I ask, were the funds advanced by Birmingham Midshire, or did they find their way to Mr. Mitchell?
Yes.
And I presume they proved to be irrecoverable from him.
Yes, I think they found their way to Mr. Mitchell and thence to the previous charge holder.
Yeah.
He was effectively refinancing.
Yes. So the issue might be looked at in this way, that the question is whether the cost of reimbursing Birmingham Midshires would fall on Ms. Grondona as the participant in the fraud who borrowed the money, or on her solicitors who negligently failed to register the charge which would have secured the loan.
Yes, that is the fundamental practical question which the case gives rise to. And that's why we submit, viewing the Canadian Supreme Court decision with that minor, but in our submission, consistent change, is fundamental to the answer the Court of Appeal should have reached. My letter friend goes on to rely upon a passage which was cited with approval by the Supreme Court from the judgment of Lord Justice Bingham, as he then was, in Saunders and Edwards. And my letter friend cites this at paragraph 24 of his written case, conveniently. Where issues of illegality are raised, the courts have, as it seems to me, to steer a middle course between two unacceptable positions. On the one hand, it is unacceptable that any court of law should aid or lend its authority to a party seeking to pursue or enforce an object or agreement which law prohibits. On the other hand, it's unacceptable the court should, on the first indication of unlawfulness affecting any aspect of a transaction, draw up its skirts and refuse all assistance to the plaintiff no matter how serious his loss or how disproportionate his loss to the unlawfulness of his conduct. And our submission, that does not assist my learned friend, because it is unacceptable that the court should lend its authority to Miss Grondona in a case in which the fundamental transaction was dishonest at heart in pursuing the solicitors for negligence. And that is not a penalty. It is not undermining or impugning property rights. It is recognizing the overarching dishonesty which marked her conduct. And whilst my learned friend will doubtless say that is disproportionate, it is consistent. And this isn't something we've dealt with in our written case, and it's a very minor point, but it might be thought that there are other areas of law where dishonesty has stern consequences, and the obvious statutory example in the modern era is, and we haven't put this before you, we can get it if it will assist you, but it's a relatively minor point, Section 57 of the Criminal Justice and Courts Act 2015, the fundamental dishonest provisions in respect of personal injury claims. If a court concludes that a claimant has been dishonest, fundamentally dishonest in respect of a substantial part of his claim, he can effect no recovery in respect of any of the claim. So in our submission, in another area where statutory intervention has occurred, it is clearly acceptable and right that where a party comes before the court in circumstances demonstrating their fundamental dishonesty, the entitlements to any recovery falls away. My lords, my ladies, finally, conscious that I'm running towards the end of my time, there have been two obviously important subsequent decisions, subsequent to Patel, in the Bank St. Petersburg case and the Singularis case. I don't think either of us, either my learned friend or myself, seek to rely upon particular passages therein. They both involved very different circumstances. And in our submission, the Bank St. Petersburg case rejected an entitlement to pray and aid a claimant's dishonesty, which was not connected with the dishonest conspiracy to remove the claimant's property. Effectively, the court being confronted with two groups of people alleging fundamental dishonesty against each other. And in the Singularis case, the company liquidator was not attributed with the dishonest conduct of the owner-director. So a dishonesty defense simply does not arise. And what is more, it was a claim brought in circumstances where the very obligation of which it was alleged that the bank was in breach was in failing to uncover the financial crime on the part of the owner-director, which was at the heart of the claim. None of those considerations can apply to the present set of circumstances. Lords, I'm slightly short of my time estimate, but if there are any other matters, the only matter I haven't otherwise dealt with is the question of discretion. If your lordships wish me to say anything further on that, I'm very happy to do so, but otherwise I will unusually stop short.
Well, there's no need to apologise for brevity, Mr. Pools. I think we can turn then to Mr. Warnock.
Can you hear me?
Yes, we can, thank you.
My lords and my ladies, what I propose to do is structure my submissions in this way. Firstly, I'm going to make 5 points in relation to the facts and issues. Secondly, I'm going to turn to the effect of Patel and Mirza, and I have 5 points in relation to that. Then thirdly, turn to the application of the range of factors approach in this case. And then fourthly, very briefly deal with the appellate approach, if that pleases my Lord. Can I start with, therefore, the facts and the issues? And the first point is to note the chronology of the events. And can I invite the court to turn to page 45, which is in the statement of facts and issues. And the first point to note is paragraph 6. Which sets out at the very end, the timing of the mortgage advance and application process. So the mortgage advance was made following an application made by the claimant on the 4th of September 2002. And then the offer of mortgage was made on the 24th of September 2002. And then at paragraph 10, on the 31st of October 2002, Mitchell executed and delivered the transfer of whole of registered title, that's form TR1, in favour of Ms. Grondona. And then it's at paragraph 11, on the 1st of November 2002, the solicitors pay that sum by way of the received from the mortgage advance to BM Samuels in order to discharge their charge, and they duly provide the receipt. And it's after that that the solicitor's negligence occurs. At paragraph 12, they fail to register at the land registry all 3 of those transactions. At paragraph 13, one sees the history of that in relation to the timing at the end of November 2002 and the steps that they failed to take. So the first point is that the actual fraud was complete before the solicitors alleged negligence in this case. The representations alleged have been made and the money received. The second point, which arises on the facts and issues, is that the solicitors accept that they owed Ms. Grondona a duty to protect her interests by registering the transfer of title to her. And of course, common ground is what we have in this situation is a cause of action. And what's being said is that the claimant should be deprived of it because of her behaviour. But paragraph 18 of the statement of facts and issues makes plain that all the elements of a cause of action are present, negligence and breach of retainer, and loss which has been properly measured. And in relation to the specific obligation to register the title, page 57, which is my learned friend's written case, makes plain at paragraph 4, item C, that Ms. Grondona had a legal interest in the property, which the solicitor was obliged to protect.
Can I just ask, why do you say that the fraud was complete as soon as the money was paid over?
Well, the fraud under, my learned friend refers to section 15 of the Theft Act. The Theft Act relates to the the obtaining a pecuniary advantage or obtaining property by deception. What was obtained here was the advance. That's obtained on the facts as found by the judge by reason of the deceits and the misrepresentations made in the mortgage application form. So the actual offence upon which my learned friend relies is complete at the time that the mortgage advance is paid. Thereafter, once the mortgage advance is paid away, there's nothing illegal, there's nothing contrary to the Theft Act, there's nothing contrary to any other provision of the criminal law in having the various transactions registered. And in fact, a point I'll be coming back to is the fact that given that property can transfer under a contract which has an unlawful purpose, it would actually be incoherent to say that there shouldn't be registration. But the third point relating to that and is the fact that it is also what the mortgagee considered the solicitor should have done. Even with knowledge that contrary to what it had been told by both the solicitors and Miss Grondona, there was a private sale between Miss Grondona and Mr. Mitchell. And we see that, if I could take you on an excursion into the appendix to the mortgagee's amended particulars of claim in these proceedings. And at page 225, paragraph 30, the mortgagees had joined the solicitors in, and one of the complaints they made was that the certificate of title, that's the COT, given by Stoffel was false and or given in circumstances where they knew it must have been taken to know it was false and were reckless, in that they certified that they were not acting for the seller, Mr. Mitchell, when in fact they were. And in passing 35H, they noted that Stoffel had also breached their duty by not reporting to them the existence of their relationship, between Miss Grondona and Mr. Mitchell. And at K, they'd also failed to report their own existing relationship with the pre-existing chargee. So what the mortgagee was saying was, well, our primary case against you, Stoffel Co, is that you should not have released the advance without informing us of all these matters. But having released the advance, you ought to then have ensured registration. And we see this at page 228.
Forgive me, I can't hear. I'm sorry. I'm sorry. I'm
so sorry.
That's all right. I'm waving my arms to try and attract attention. I've got your point on paragraph 30, Mr. Warnock, but I'm sorry, I didn't hear you after that.
What I was saying was that paragraph 35H, one of the bank's complaints was that Stoffel had known of the relationship between Mitchell and Miss Grondona, but not reported that. And at K, Stoffel had also failed to report the fact that they had also acted for had a relationship with the existing charge holder on the property.
Thank you.
And the Stoffel bank's case essentially was that up until the point Stoffel made the advance, if Stoffel should have reported these matters to it. But having made the advance, Stoffel's duty was to get on and register the various conveyances. And at paragraph 36, they set out their case that despite stating that they had obtained a mortgage deed in favour of the bank and a transfer of the property to Ms. Grondona, Stoffel had neither registered the transfer nor the mortgage, nor submitted those documents to the land registry, nor provided them to the bank. And at paragraph 37D, their complaint of the advance and or within the period of protection afforded by the land registry searches, they'd failed to take the steps to do those things.
Thank you.
The fourth point I'd like to make on the facts and issues, and it's a point my learned friend has adverted to already, is that it is common ground that this is not a case where Miss Grondona is seeking to profit from the illegality. Now, it is, of course, right, as he says, that when she embarked on her dishonest arrangement with Mr. Mitchell, that they no doubt hoped to make money out of it, just as Mr. Patel hoped to make profits out of his insider dealing in the Patel and Mirza case. But the issue is whether the court, in allowing a cause of action which undoubtedly otherwise exists, is lending its support to someone profiting from illegality or not. And here that is not the case. As I say, it's common ground on the facts. It's common ground on the facts and issues that Miss Grondona suffered a loss and she is suing for that loss.
Can I just interrupt for a moment, Mr. Warnock? I have lost the video feed from Lady Arden. Is that just me, or are you in the same position?
I don't see her either.
Well, we can't continue until we can see her, and I don't know if we can hear her either.
She's back. I can see her, but I can't hear her.
I was listening to what was being said. Thank you.
Thank you.
My lords and ladies, my fifth and final point on the facts is that the contract, the transfer between Mr. Mitchell and Miss Grondona was not executory. Completion of this transaction had occurred. And can I just pick up a point on my learned friend's case at paragraph 36, which is page 73. On page 73 at paragraph 36, my learned friends say, well, it's trite law that the court will not give assistance to executory provisions of an unlawful contract, whether the illegality is apparent ex facie the document or whether it emerges during the course of trial. Then at point C, they say it would be inconsistent if the court would refuse on those well-established grounds mentioned by Lord Jauncey to order that the register be rectified to record the transfer from Mitchell to Ms. Grondona, but nevertheless awarded her damages for failing to do so. In fact, that is not a point which is open or within the ambit of this appeal. If I can invite you back to paragraph 26, or sorry, page 26. To the grounds of appeal, ground 3 was that the court would not have ordered registration, nor would the land registry. And that was a ground on which my learned friend was in fact refused permission. And indeed, rightly refused, because who was going to object? Setting aside the fact that the transaction was actually completed, in that Mr. Grondona had done, or sorry, Mr. Mitchell had done all he could to transfer the legal title to Miss Grondona. Who on earth was going to object to registration at this point? Because, as we've just seen, certainly not the mortgagee. Those are my points on, by way of opening observations on the facts and issues. But can I make a few points in relation to Patel and Mirza? The first point that we make is that the ultimate aim in which the court is involved in applying the illegality defense is avoiding inconsistency and disharmony in the law, legal incoherence. And if we could go to Patel at paragraph 99, which is on page 359. Lord Tolson said, looking behind the maxims, there are two broad discernible policy reasons for the common law doctrine of illegality as a defence to a civil claim. One is that a person should not be allowed to profit from his own wrongdoing. The other linked consideration is that the law should be coherent and not self-defeating, condoning illegality by giving with the left hand what it takes away with the right. And then there's paragraph 100, which my learned friend has already taken you to in relation to Hall and Herbert, and Mrs. Justice McLachlan's concern that courts should not be focusing too much on what the claimant's getting out of it, but ultimately at letter F should be focusing rather on the question of whether allowing recovery for something which was illegal would produce inconsistency and disharmony in the law, and so cause damage to the integrity of the legal system. Lord Toulson said that's a valuable insight with which I agree. And the range of factors test, which his lordship then goes on to set out, and with which the other members of the court, including my Lord Hodge, agreed, then set out a structured approach, a range of factors approach aimed at answering, which aimed to answer the question whether or not that ultimate aim would be breached and inconsistency and disharmony in the law introduced. The second point in relation to Patel and Mirza is that the old law is not irrelevant, we submit. And in many, perhaps indeed the vast majority of cases, the old cases are likely to have been decided in the same way under Patel and Mirza. Many of the old rules still have a role to play in the range of factors test. And in fact, in paragraph 101, on page 500, sorry, page 360 of the bundle, at the very top of page, the very end of paragraph 101, having set out the threefold structured test, Lord Toulson said that trio of necessary considerations can be found in the case law. In other words, the test in Patel and Mirza did not come out of the blue, but was an attempt to formulate the law, taking account of what had gone before in a way which would be more open in relation to what the courts were doing. And in fact, earlier in his judgment, Lord Toulson, at paragraph 69, which is on page 352, at paragraph 69 on page 352, he referred to his judgment in the Parking Eye case. And he said that what he had said was, rather than having over complex rules, which are indiscriminate in theory, but less so in practice, it is better and more honest that the court should look openly at the underlying policy factors and reach a balanced judgment in each case for the reasons articulated by it. 53, this is not to suggest that a list of policy factors should become a complete substitute for the rules about illegality in the law of contract, which the courts have developed, but rather that those rules are to be developed and applied with a degree of flexibility necessary to give proper effect to the underlying policy factors. This is a point which Professor Burrows, whose views were so, can you hear me, Lord Lloyd-Jones? Sorry. I thought Lord Lloyd-Jones had his hand up.
It's simply that for a moment the line went dead, but it came back.
Thank you. The range of factors test obviously owes a lot in its development to the writings of Professor Burrows. And he, writing after this judgment in Patel and Mirza, in the chapter to which my learned friend has taken to you, called Illegality After Patel and Mirza, A New Dawn, says this, if we could go to page 670, please, 670. Page 670 of the bundle, it's about halfway towards the bottom of the page, the last paragraph. It begins, in this respect. And what he's dealing here with is, he's said that some commentators have criticized Patel and Mirza on the basis that the Supreme Court were essentially acting as legislators in coming up with a new test, which was to apply across the civil law, not just in relation to the claims of unjust enrichment they were dealing with. But he said, and he says, in this respect, however, it might be said that Patel and Mirza is controversial precisely because it did not involve a typical incremental development requiring the overruling or distinguishing of a particular past case. That's the argument he's dealing with. He says, this may depend on how one views the impact of Patel and Mirza on past cases. The decision did not, as such, overrule past cases. Rather, what has been set up is a method of analysis, so that what the courts must now do is justify, as far as possible, the results in past cases through the prism of the trio of considerations approach. So, for example, Lord Toulson indicated that the result in Tinsley and Milligan was correct, applying the new approach, even though its reliance rule reasoning was rejected. A useful analogy here may be the authoritative recognition of the law of unjust enrichment in Lipkin, Gorman, and Cartnell. That decision did not wipe away all previous relevant cases based on implied contract reasoning. But what the courts have since been required to do as a matter of binding precedent is to rationalize the results of past cases so far as possible through the lens of unjust enrichment reasoning. In any event, it is incorrect to regard Patella Merza as falling outside the incremental traditions of common law development. The factors that the courts are being required to take into account are those which have been culled from past cases, and the approach laid down did not come out of the blue, but had been discussed both judicially and by academics and by the Law Commission for decades. I suppose another example might be the recent restatement of the law of the duty of care and the tort of negligence, which my Lord Reid has authoritatively stated in a number of recent cases, starting with Robinson and the Chief Constable of West Yorkshire. Prior to that decision, many of the old case law and cases on duty of care had purportedly been decided by applying a threefold test said to arise out of the case of Caparo and Dickman, in which the Supreme Court said hadn't really been created by that case at all. But it doesn't follow that all of the old cases are wrongly decided. Many of them, perhaps nearly all of them, are likely to be decided the same way, applying the orthodox common law principles which the Supreme Court identified in the Robinson case. So I suppose in short what I'm saying is Patel and Merza, it's not a complete revolution where one throws everything up in the air and says what went before doesn't matter. It's a question of what the court feels right in the particular case now. But it's a method of analysis which should actually, consistent with common law incremental approach, largely produce the same results. The third point I make on Patel and Merza is that it abolished the rule or overruled the rule that if you had to rely on your fraud to establish your claim, then the claim would fail for illegality. But it does not follow from that the question of reliance is nonetheless irrelevant. The particular concern which was addressed in Patel and Merza was the automatic barring of cases where somebody had to rely on their illegality in order to get their remedy. And for instance, the example which troubled the Law Commission a lot was the example of the presumption of advancement. So somebody like Miss Milligan would not have succeeded in her claim against Miss Tinsley had the presumption of advancement applied between them. But that's not to say reliance is irrelevant, because proportionality, as Lord Toulson said at paragraph 107, a passage my learned friend has taken to you, includes a number of factors, one of which is centrality. And that centrality of the illegal conduct to the contractual obligation. And it's a point we make at paragraph 48 of our case on page 89 of the bundle. That although following Patel and Merza, the question of whether the claimant must rely on illegality is no longer determinative, it must be highly relevant to centrality, because the essential facts of the claim can be established without reference to the illegality, then illegality is unlikely to be central to it. I have two more points to make on Patel and Merz. I think I'll probably make the next one quite briefly. The fourth point is, it's not the role of the civil courts to punish. And can I invite the court to turn to page 361 of the bundle, which is in Patel and Merz. At paragraph 108, 108. His Lordship said that the integrity and harmony of the law permit, and I would say require, such flexibility. This is in relation to the list of factors. But part of the harmony of the law is its division of responsibility between the criminal and civil courts and tribunals. Punishment for wrongdoing is the responsibility of the criminal courts, and in some cases, statutory regulators. It should also be noted that under the Proceeds of Crime Act 2002, the state has wide powers to confiscate proceeds of crime, whether on a conviction or without a conviction. Punishment is not generally the function of the civil courts, which are concerned with determining private rights and obligations. And the broad principle is not in doubt that the public interest requires that the civil courts should not undermine the effectiveness of the criminal law, but nor should they impose what would amount in substance to an additional penalty disproportionate to the nature and seriousness of the wrongdoing. And this division, which is a recurring theme in the cases, is that there shouldn't be, feeding back to what Mrs. Justice McLachlan said, the concern is that the law shouldn't give with the left hand what it takes away with the right. But it is not the function of the civil courts to do the criminal law's job for it. What it should not do is undermine the criminal law. The fifth point that we make from Patel and Merz is that the Supreme Court did not cast any doubt on the fact, and it's not an issue in this appeal, that property transfers under an agreement which has an unlawful purpose. And can I invite the court's attention to paragraphs 110 and 111 of Lord Toulson's judgment. And Lord Toulson here says, it's on page 362, I'm sorry, at the very bottom of page 362 of the bundle, paragraph 110. He says that I agree with the criticisms made in Nelson and by academic commentators of the reliance rule as laid down in Bowmakers Limited and Barnard Instruments Limited and Tinsley and Milligan. And I would hold that it should no longer be followed. Unless a statute provides otherwise, expressly or by necessary implication, property can transfer under a transaction which is illegal as a contract. Sajan Singh and Sandara Ali and Sharma and Simposh Limited. There may be circumstances in which a court will refuse to lend its assistance to an owner to enforce his title, as, for example, where to do so would be to assist the claimant in a drug trafficking operation, but the outcome should not depend on a procedural question. In Bowmakers Limited and Barnard Instruments Limited, the claim was for conversion of goods, which had been obtained by the plaintiffs and supplied by the defendant under transactions which were assumed to be tainted by illegality. The Court of Appeal rightly said that a man's right to possess his own chattels will, as a general rule, be enforced against one who, without any claim of right, is detaining them or has converted them to his own use, even though it may appear either from the pleadings or in the course of the trial that the chattels in question came into the defendant's possession by reason of an illegal contract between himself and the plaintiff. But it added the qualifying words, provided that the plaintiff does not seek and is not forced either to found his claim on the illegal contract or to plead its illegality in order to support his claim. The objections to the proviso have already been identified. It makes the question whether the court will refuse its assistance to the claimant to enforce his title depend on a procedural question, and it has led to uncertain case law about what constitutes reliance. The court ended its judgment by saying, "We are satisfied that no rule of law and no considerations of public policy compel the court to dismiss the plaintiff's claim in the case before us, and to do so would, in our opinion, be a manifest injustice." That conclusion, rather than the answer to a procedural question, should have been the end of the illegality defence, since it's based on public policy. The issue of the transfer of title was also dealt with by Lord Sumption in his, he of course was in the minority on the application of the range of factors approach, but not any disagreement about this. At page 395 of the bundle, at page 395 of the bundle, paragraph 236, at the bottom of the page, referring to Tinsley and Milligan, he said at letter G, just between letter G and letter H, there were two stages in the reasoning of Lord Brian Wilkinson, who delivered the leading speech for the majority. The first was that where property is transferred for an illegal purpose, the transferee nevertheless obtains a good title, notwithstanding that the transaction being illegal, it would not have been specifically enforced. This is so whether the title in question is legal or equitable. The decision of the majority on this point settled a question on which there had been inconsistent authorities dating back to the beginning of the 19th century, and it did so in a way which reflected the law's traditional reluctance to disturb settled titles. My lord, ladies, those were the points I wanted to make on Patel and Mertz. So before turning to its application, I wonder if now is a convenient moment.
Yes, it certainly was. We'll adjourn now and resume at 2 o'clock.